for delivery of judgment WPC 8037/18.
The writ petition is dismissed.
Lordship. May I please request? I don't know, in item number 32, my lord, yesterday we have filed affidavit, they did not reports, I call 32.
May I please, Your Lordship? My lord, item number 39 may kindly be adjourned, Your Lordship, for 2 weeks, Your Lordship.
39.
39, Your Lordship.
After 2 weeks. Both sides represent on the prayer made by and counsel to the petitioner. List after 2 weeks.
Lord,
You will
I read in item 52, my lord, hearing matter. In this case, my lord, just today, my lord, I have been engaged with the counsel. Need to go through the file, my lord. Maybe taken after 2 weeks. 52.
2017 matter.
Today I have been engaged, my lord, just come, today only.
Okay, give a fixed date after 10 days.
Yes, after 2 weeks. 52.
Same order.
May I please, Your Lordship? I wish to mention, in respect of item number 35 and 36, Your Lordship. Both the matters may be upgraded, Your Lordship. Item 35 and 36 matter.
Okay. Okay.
Lord, in item number 4, my lords, of today's list, I have separated an adjournment slip. In item number 4 of today's list, I have separated an adjournment slip, may be taken up after 2 weeks.
Give a fixed date after. Same order.
Tablet.
May I please, Your Lordship? With the consent of other side, I pray for an adjournment of item now 31 of today's daily course list. I have also submitted the adjournment slip yesterday.
31.
31, item now 31. And the Lordship, there is an interim order that may be continued till the next day.
31. Just wait for some time. Let me have the record. Just wait for some time. Yes.
May I please, Your Lordship? I would like to mention item 18. Can we adjourn this matter for 1 week? Fix this matter up to 1 week.
18 is 2016 matter. You'll have to wait.
May I please, Your Lordship? I beg to mention item number 42, Lordship. Engaged counsel R.P. Hazarika is not there, Lordship. He is out of station. So matter may be adjourned for today, Lordship.
42.
42.
Okay, make it 2 weeks.
So, Lordship, date may be fixed on 29 or 30, Lordship.
It comes after 2 weeks.
Deeply, Your Lordship.
May I please, Your Lordship? I beg to mention one item, Your Lordship, item number 32. In this case, government, it's a NSA matter, Your Lordship. Government has filed their affidavit that has not been tagged, Your Lordship.
It's calling it.
No, another affidavit has been filed, Your Lordship, both commissioner by commissioner of police, Your Lordship. This may also be brought to record, Your Lordship.
Give a slip. If it is not there, we'll call it.
Lordship, and may I make a prayer for upgradation of the matter, Your Lordship, before Your Lordship rising or at 2, Your Lordship?
Okay, 2.
Lordship. Deeply obliged, Your Lordship.
Item 31.
Your Honor, in this matter, yesterday we have filed I also.
There's no interim order.
Wrong. There is,
There's no interim order. The court merely said that whatever happens will be subject to outcome of the writ appeal. There's no interim order to be extended. That's not an interim order. Subject to outcome of the writ appeal. Whatever decision is taken will be subject to outcome of the writ appeal. It's not an interim order. The chair made by and counsel for the what says that represent the respondent numbers 1 and 2 are one and two. All sides are represented. The prayer made by land counsel for the appellant, we have it down today. Next, the learned counsel for the appellant has prayed that the interim order passed to list be extended till the next date of listing. Next para. This court by order dated 9/4/2024 merely provided that the decision of the Bharat Petroleum Corporation Limited for appointment of regular or rural retail outlet at Pogijan, PUGIJAAN, under Golaghat district shall be subject to outcome of the writ appeal. Under the circumstances, there being no interim order. The proceed of observation of order dated 9/4/2024 shall prevail. Next up, this on the date.
Daily list item 1 for motion.
May I please, Your Lordship? May I please, Your Lordship?
Yes,
In this case, I have to obtain some instruction. Madam, after 4 weeks, Your Lordship, but I am unable to contact the petitioner also because phone number is not functioning, Your Lordship. Long back it was given. There is communication back for a long time. Yeah, if I come after 3-4 weeks, then I will.
pleasure. Think you the projection made in this video. It is. We should look at number for it, that preparing and request the. Next, this is the matter in the admission column on 6/2/2026.
God bless you.
Item 2 for motion.
May I plead your lordship, kindly matter may be passed over after something? Worship. I think to
Just wait.
I think.
Yes. Sizes of the matter. Right,
Basic, two.
63 to seconds. Go and 65, 7. Yeah. Ms. Verma, we are issuing a notice in this matter. We would like you to examine what there are two records.
Two records, brothers is also there.
You have to go through it and address us in respect of both the records. You would like to have records,
Lordship, let the other record also come.
both records are there.
Both are there. Yes, Lord.
We are issuing a notice and fixing it for admission hearing. No, this that. I actually will share up this with them. But this you say and transfer the petitioner and so and so for the respondents. The records of two cases, two reference cases for is received and are received. Accordingly, what is inclined to issue notice on 6/2/2026. On the prayer made by the standing person for the FT matters of the records of FT case number FT within bracket D 847 of 2012 and FT case number 349 of 2011 are handed over to.
Lordship may record the name of Mr. Gunjan. Lordship, he will have the records in his custody. I'm not in town at that point of time.
6/2
Yes, Lordship. 6.
for admission.
We may be allowed to inspect the record.
Speak out.
Item 3 for motion.
Provide benches of easy. Is that if it's a appearance of
No?
on the immediate appearances. It was said.
Lordship may not like to take up this matter. Lordship may do.
Item 10 also.
Very good.
At 10 also.
Okay.
Milord, item 10 also.
Item 10 also.
Remember? 29. 29. 29 also, Milord. Lots of
Eight
people.
also.
Put there.
Item 5 for motion.
May it pleases your lordships. My lord, here we are supposed to file an affidavit. We had given for filing on yesterday. So it was in the second half, so it's not there in the record. Yesterday evening, we have given to our clerk, so maybe he has kept ready, so today it will be filed, lordship. Deeply obliged, lordship.
Item 6 for motion.
May I please your lordship? Lordship, interim order at page 49. Here, my lord, a document that is exhibit B, it is citizenship certificate. That is the sole document has been exhibited before exhibit number B. Yes. This is the sole document that it is before the cutoff date. And migration certificate was annexed in a written statement, but could not produce the original. And my lord, exhibit B in my petition, it is page 16. Sixteen is the type copy, 17 is the original Xerox copy. Here, my lord, learned tribunal has opined that the issuing authority that upper column is blank, so this document cannot be relied upon. But I have stated in careful observation in lower part also, but this alphabet are faded due to this my lord. So authority is mentioned is my lord. Originals I have not my lord with me. It is faded in this alphabet, but otherwise it is additional deputy commissioner, Dorong it is mentioned. My lord. Actually, my lord, original was with me, but This SIR, it is started, he took, took from me, well, that original. I can produce some later on. That's why I can do this. No, my lord, citizenship certificate, it is concerned, it is original, I have seen, my lord. But migration certificate, there is no original. Therefore, my lord, my lord, that was exhibited in. Yes, my lord. But so far I have seen, my lord. Yes.
Yes, Lordship.
No, madam, in my humble submission. In my humble submission, it is. My lord. My lord, migration certificate is, was, Xerox copy was there. But if my lord allows time, I will produce it next week, my lord. But in the record, it is. My lord. My lord. As it is, my lord, in the exhibit, it is shown as compared to original. So therefore, my statement is this, my lord. And the document was with me, but this SIR has started, he has took it from me. My lord. Otherwise.
I don't know.
Yes, exhibit B, school certificate. But the authority of that school certificate was not called upon for, yeah, examined. And exhibit C was the Patta land, Karasmati Patta. It is 1976, wherein the name of the petitioner has been shown here. My lord. It is exhibit A. Here it is, my lord, page. Yes, ma'am. Witness mother had deposed as a DW2. No, my lord. So this document was not proved in original. Yes, my lord, in exhibit D, there is no, his name is showing as a voter, but it is against the mother of the petitioner, that husband is Suresh Nag. And in also against the petitioner's name, his father's name is Suresh Nag is reflected in exhibit D, 1989 voter list.
Political department party association. petition.
Petitioner, I don't know what it is. '89, it is 1977 is there. Exhibit E, and find name of the mother of the petitioner. 1977, Malati Nag. Malati Rani Nag. Page in my petition is it is 18. 18. 18, original is page 20.
Will be defending their agents.
Paternal uncle of the petitioner Shamal Nag, his name was also reflected in 1977 voter list, exhibit H. He had deposed before the Lana tribunal. Hello. Hello. Yes, yes, hello. Registration, it is 5/8/1967. Yes, madam. I have. It is 31 years. Yes, sure. He died in 1973 as per the, my lord. Yes. My lord. Mother has said, my lord, in page 24 that yes, 27.
Lordship, I just.
Yes, yeah, it is said that 31 years of age he had died. But my lord, in this case, I would submit that mother is a literate woman and maybe on guess she has said it.
Statement is false. The evidence, in evidence, your mother gave a false statement. Have you said that?
I haven't said mother.
According to you, when you
Hello.
when did the petitioner, what is the year of birth of the petitioner?
1972.
1972.
True, my lord.
You come to the the examination of DW2 3.
3. Yes, page 24, 34. He said that 1967.
67.
Yes, ma'am. So there is mismatch of dates. And he also said here, my lord, that my elder brother, late
You
Suresh
see, this
Nag,
mistake will never happen.
my lord.
67 is the year when you entered into the into India from Bangladesh.
1965, it is as per migration certificate,
Whatever be,
my lord.
this is page 17 is 65.
Yes,
You just now said 67.
It is migration certificate, my friend.
No, page 17 of your petition.
Yes, it is 67. It is a registration. But
That is 67, and therefore this is a date you will never forget. No one in your family will forget. When you came from Bangladesh to India,
my lord. No, here it is, DW3 has mentioned that in 1965, he had came into India along with his elder brother, Suresh Naik. It is 1965, he said. And DW3 also said that his brother had died at the age of 45. So there is a mismatch. And saying that it is a fact, Mala, that they came into India 1965 and got a registration in 1967. But so far concerned with the migration certificate, original has been destroyed, only Xerox copy is there. Whereas Medipatta, it is also exhibited, but here it is the date is not date is 1976. But learned tribunal has discarded this document since it was not pleaded in the written statement. Name of Malot, Uncle Shamal Nag as well as mother was reflected in the migration certificate along with the father. That was not exhibited. Mal, I will put a small. My lord, I will put this one. Tabla İsmail. Please.
Item 7 for motion.
May I please your lordship? Lordship kindly pass over the motive for the time being. God bless lordship.
Item 8 for motion.
May I please your lordships, this matter, I think appropriate branch to be listed. My lord Justice Kalita earlier appeared. In the IA lordship thereafter filed, that's name reflected, IA disposed of, that is. IA 2850, order sheet. And similar, the item number 26 also, that is, I have 26, Habibur Rahman, that case is similar. Oblige news.
Item 9 for motion.
May it please the lordship. My lord, in this case, my lord, the record was called for and the same is received. My lord, maybe fixed for admission, my lord. I will.
Favorable.
Item 11 for motion.
May please, your lordship. Well, Lord, here in this case earlier record was called for, record is received, my lord. My lord. Opinion, lordship will find at is 115.
Yeah.
Yes, my lord. Marriage certificate was not proved. My lord, evidence in chief was submitted, but there was not given opportunity to prove to examine cross-examine the Kazi, my lord. And has been an order dated 36/2018. The learned trial court has rejected the pair that another date may be given to cross-examine the Kazi. That was rejected, saying that earlier date was also absent. So, my lord, that part is very important, my lord. The woman does not have any linkage with the father. That opportunity is to be given, my lord. In page 6 of the order sheet, my lord, this rejection of the my lord, prayer for cross-examining the Kazi was rejected.
The marriage register did not come. that account, because that evidence was closed. I think we should get an opportunity to prove that. One opportunity must be granted. Their order was not challenged. But still in the challenge the writ petition. But Mr.
You have taken a plea on that?
My lord, yes, my lord.
Where?
In the writ petition,
Where?
because your statement is incorrect here. You have given the statement at page 26. Paragraph 17.
My lord. Kazi was not examined, cross-examined. Always took steps to bring him before the tribunal.
But the tribunal did not proceed for cross-examination. Number
My
one,
lord,
tribunal
my
does
lord-
not cross-examine. Number two is that he was never there in the order. So
My
he is
lord,
incorrect.
my lord, the statement, my lord, has been made hearing the lawyer of the trial court, and we could not see the records, my lord. Therefore, my lord, we have committed some mistake, my lord.
Make an amendment because otherwise we can't allow your prayer. Amend your petition if you want.
Yes, my lord. Yes, my lord. Well, but this, on record, my lord, everything is there, lordship. Took cognizance of the judicial notice of this order, my lord.
We are in statutory jurisdiction. It's not a writ petition.
My lord.
Otherwise, in under 226,
My lord.
yeah, and mandamus was, it's not there, it's statutory. Okay, both as represented. Mr. A.R. Sigdal and counsel for the petitioner submits that there some inadvertent error has crept in the writ petition and prays to amend. Prays to file an interlocutory application for amendment of the writ petition. Prayer is allowed, matter stands adjourned today. List. List on. How much time do you need?
My lord, at least, my lord, 10 days is required, my lord.
10 days is required, okay. List on 11/2/2026.
My lord. Deep lovely.
Item 12 for motion.
None refused call for the petition or all the respondents are represented. Bench of justice, the matter stands adjourned today. Please make clear that if the petitioner remains absent on call on the next date of listing, his orders will solve. Next, he will restore 4/2/2026.
Item 13.
May I please? What? My lord, earlier occasion, my lord,
Appeared in this matter.
Hmm?
Lordship had appeared in this matter. Item 13, Lordship.
Both sides are represented. This is the matter before any other bench without one of us. Within that, honorable Mr. Justice. PM Parikh.
most obligable.
Item 14 for motion.
Here, impugned order is at page 60.
Take the other format from my secretary. I'm probably giving the relevant. Huh? But Mr. A.R. Sigdar, learned counsel for the petitioner. Also, it's for the respondents. Page 60 is the opinion dated 11/4/2025. Passed by so and so. I'll give you tick mark. Passed by so and so in case number so and so, in ring number so and so. Thereby declaring the petitioner to be a foreigner who has entered
In full petition. So I don't know, 6 hour policy.
Assam within bracket India on or after 25/3/1971 from the specified territory of Bangladesh illegally without any valid documents. The notice returnable in 4 weeks. Extra copies within 2 days, or for the records. To the following email address of the learned tribunal. Next. The prayer for bail is opposed by the learned standing counsel for the FT matters. Stop. Custody decision made in this petition. Then the operative parties 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police within bracket border, bracket close SIP secretaries. List of police and missing.
Deep lovely person.
Take a break and come back. Yes.
My lord, I am sorry to mention at this stage, my lord, in respect of item number 28, my lord. I have checked the record, my lord, some documents and 2, 3 witnesses I have not annexed, the cross part. So I may be permitted to file additional affidavit and registry may be.
That is not required, we can go through it, if it is a matter of record. You cannot take the trouble. You can adjourn the matter, but we will not take the trouble, we can read it through the.
Some annexer also not, because at that time of filing, authenticated copy was not with me, man. Now record has come, if I take copy from the record, then I can file additional affidavit.
For that, you'll have to file an application before the authorities, you can't allow copies from here. You have to apply for certificate copy and get it.
Then after 2 weeks, matter will take.
If you are making a note of it, ask someone to make a mention, we'll
No,
address it. When
I am.
it is called. Yes, item 15.
May please, your lordship, should I need to have some more time to obtain certain instruction for my client lordship?
on the motions that presented on the prayer made by the Land Commissioner. Release the matter on.
After 1 week, yes.
Release the matter after a week.
Public.
Item 16 for motion.
May I please, your lordship, my lord? My lord, in this case, my lord, earlier a writ petition was preferred, my lord, and the only linkage with the petitioner is the deposition of his father, my lord. And the father was not cross-examined, my lord. Accordingly, my lord will find at page 65, the operative portion at page 67, my lord. That was writ petition number 1190 of 2017, my lord. That was remanded back, my lord, to the concerned tribunal, my lord, allowing the, my lord, petitioner to cross-examine the DW2, who is the father of the petitioner, my lord, and also to ascertain whether his name, my lord, which appeared in the voter list of 1971, is the same in one person or not, my lord. Thereafter, my lord, I appeared before the concerned tribunal along with my father, my lord. Page 68 is the cross part of the, my lord, father, my lord, DW2, my lord. He made some specific averments, my lord, regarding his daughter, that is the petitioner, my lord. But he could not say the date of birth and the, my lord, year of marriage of his daughter, my lord. And these are the basically two reasons, my lord, primary reasons for which, my lord, again, the petitioner was declared to be a foreigner. The impugned order is at page, my lord, 71, annexure 16, my lord. Fresh and final.
Just
opinion.
District Portfolio में Moregaon. Moregaon. Soy duitas.
My lord, the averments, if your lordship, my lord, kindly compare the earlier, my lord, oral deposition of the father along with the cross part, my lord. Let's say when accept the year of, my lord, birth of the petitioner and the, my lord, year of marriage, my lord. He had made a specific, my lord, averment that the petitioner is 45 years old, my lord, then. In the cross part, my lord. In the, my lord, page 68, my lord, annexure 15. In the fourth line, my lord, in the typed copy, my lord, it is specifically made that Hamida Khatun, she is the petitioner, is 45 years old. He, my lord, the father of the petitioner, my lord, he had hardly, my lord, studied up to class 3, my lord, and he is a man of, my lord, 78 years then, my lord, in the year 2023, my lord. My lord, this much, my lord, we can expect from a man, my lord. No, my lord. My lord. My lord. Now, if my lord goes through the. Yes, my lord. But my lord, his depositions and the, my lord, the cross part, my lord, this is very specific that this lady is the daughter of this particular person, my lord. And other than, my lord, the oral deposition and the cross part, my lord, this lady has nothing to show before your lordship, my lord, that she has a linkage, my lord. Because she could not cast vote, my lord. The examination in chief of the, my lord, father is at page 49, my lord. There also, my lord, annexure 10, my lord, he made some specific averments, my lord. In fact, before the tribunal also, my lord, on earlier occasions.
Yes, lordship.
Mm.
72, lordship.
Yes.
Yes, lordship. At 74.
74, my lord.
74, lordship. Yes,
Yes.
that is on the directions of this court. On the specific directions which this court had passed in the writ petition, lordship. Um, 67, no?
Yes.
Lordship, at page 67, the High Court order, lordship, at paragraph 6. The matter is remanded back to the Foreigners Tribunal, Morrigaon, to enable the Home Department to cross-examine the DW2 Abdul Hakim. The Home Department shall also verify as to whether DW2 are one and the same person. The petitions from here, the tribunal has picked up, lordship. There, like at page 74, the story continues from here, lordship.
Lord, in fact, the tribunal has not said whether this Abdul Hakim, as per the direction of this honorable court, my lord, at para 6, my lord, it was also directed that Abdul Hakim and Abdul Hakim of voter list of 1971 of village Senimari are one and same person. The tribunal, my lord, did not say anything regarding this part, my lord. Whether this Abdul Hakim is the same in one person or not, my lord, there is no whisper, my lord, in the later part of the fresh opinion.
She has mentioned here, it may be mentioned here, page 75. Page 75, it is there, lordship. Second paragraph.
Linkage or whatever, the one person or another.
That specific word is not required that he is one and the same person, lordship. She mentioned about the relationship with the purported father, lordship.
May I pray for
25th
one thing,
February.
my lord? May I pray for one thing, my lord, till the next date, my lord, she may not be deported. That much, my lord, declare. No direction may kindly be given. Yes, my lord. But I'm Morigaon, my lord. My lord. Deeply obliged, my lord. Deeply.
Item 17.
Worship hearing, your lord. Mr. S. Ahmed is the youngest counsel herein, but he failed to attend today for his personal difficulties. And I was informed, your lordship, to make a mention for listing this matter in some other days, your lord. Yes, yes.
Passed by so and so in case number so and so. Reference case number so and so. Thereby declare the petitioner to be a original of post 25 to 1971 stream. You should notice returnable in 4 weeks, extra copies within 2 days. Call for the records from the concerned tribunal, the following email address. Next one. Prayer for bail is opposed by the Learned Standing Council for the FT matters. Next paragraph, considering the projection. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border Borpita. List after 4 weeks. Yes, Mr. Khan, any objection?
No, no.
Supply item 53 for motion.
Impin order is page 101, my lord. Madam.
Sir, Verma, I think your authorities should make an inquiry with this, in this tribunal. Come to page 101.
Good attention.
No, if the steno is not working, they have to change it.
But
Every now and then we find her, this office, her handwriting is in a complete handwritten form. No, the tribunal should be given some substitute there, what they call this officer should have a stenographer. Hmm?
Logic all said and done, she has got a very nice handwriting. Very, very neat and clean,
Immediately.
totally in order, Lordship.
Very neat and clean, but the problem is that we think that she is perfecting her handwriting because she has to write it every time.
Yes.
No, it is quite a task, but Lordship,
Since
this is appreciable also.
19 case.
appreciable, but you see, the efficiency comes down.
Yes, Lordship. It's quite tiring also to write.
Not tiring, you write so much.
And that too, Lordship, without any line, Lordship will see none of the lines have gone up or down, Lordship.
No, this is because it's because this is not the, we don't know whether this is the actual handwriting or it's is the copy's handwriting of the copyist. We don't know.
It is written by, copied by somebody, compared by somebody.
No.
On 119, Lordship.
No, we don't know because otherwise our copy, type copy also, somebody says that copied by, compared by, we are not on that. But the fact is that the police
Lordship,
officer will also always find it in the handwritten form. Most of the time.
4, 7 as well.
Same order, just like the last. Heard Mr. A.M. Ahmed, counsel for the petitioner, and so for the respondents. Opinion is at page 88. Dated 31/10/2025,
25.
passed by so and so in case number so and so. Please border case number so and so. Preparing the petition to be a partner of post.
These are what like 05.
Probably in 4 weeks, 4 copies. Copy the records to the following email address of the learned tribunal. Prayer for bail is opposed by the learned standing counsel for the FD matters. Considering the projection made in this petition. 10 days time to take bail out of this 5,000 to the satisfaction of Department of Police Border, Nagaon.
No.
Next country. The court is inclined to, next paragraph, the court is inclined to take notice of the fact that in respect of the opinions rendered by the learned member from a foreigners tribunal 9th Nagaon, most of the times the opinion is in the handwritten, is handwritten. So therefore, it appears that either the particular tribunal does not have a stenographer or a typist, or the typist is, or the typist or the stenographer is not in regular attendance. So accordingly, we directly Home and Political within bracket B, bracket close department, to make an inquiry as to whether the assistance of a stenographer or the typist is provided to the learned member from a foreigners tribunal 9th Nagaon to further make inquiry as to if the service of stenographer oblique typist is provided from a is the said typist oblique stenographer is in regular attendance. Next, we request the learned standing counsel for the FP matters to send a downloaded copy of this order to the authorities in the Home and Political within bracket B, bracket S department to further an inquiry. Submitted report. Preferably by the next date of posting. Next, list of phone solicit with the tribunal's reports.
No, please.
Upgraded item 51 for orders.
May please announce.
Yes.
This honorable court has already passed the order, but lordship, inadvertently, we have written the address in the order, which is his original address. And but in the opinion, lordship, that is written is some other address, my lord. That is why lordship, when placed this order before the SP, lordship, has stated that the which is written over the opinion, that should be reflected in the order, my lord. Opinion is at page number 62 of the repetition, my lord. Here it is written as Nelly Dohati Habi under PS Zagirod Morigaon, and we have written his original address in the cost title, my lord. That is our inadvertent mistake, lordship. Both the order, both the address, we should have written over that, lordship. That is inadvertently left, lordship. The main petition, yes. Main petition original address first, opinion of two, I mean, I don't know what I see, the road works. It will argue around it, the ruler is. Please stop.
You allow the application? This is- Oh. Then you have to withdraw this and you have to file it again. Because in this interlocutory application, now you have not given a second cause title with the correct address. You see your application, if your address is changed, in your application, you did not give the second address,
In the cost title,
the cause title.
but in paragraph number 4, I have written, my lord.
No, that you know the procedure.
I'll file the amended one, lordship, along with this.
But here in your interlocutory application, the amended cost title is not there. You have still given the earlier cost title. Statement inside is that the address is changed. But again, in the cost title, earlier cost title has come, Potia Sapuri.
Yes. My lord, without any order of amendment, lordship, we cannot place that one, lordship.
No, in your interlocutory application, you will definitely give. That's
Yes.
what the procedure is.
What is it?
Application to one, I believe, format one.
Again, thank you.
Into two four photos, and there are by the amendment cost title in the both.
Then I'll file the, my lord, amended cost title, lordship, along with this. Both lords.
Because you have to withdraw this. You withdraw it and file it again.
Yes, I just told her when lordship asked. She'll have to withdraw this petition, lordship, because the whole sequence is wrong. But I may be allowed to withdraw this one, I'll file
Withdraw
this
it,
one,
file it again.
lordship. এতিয়া ফেল কৰি এইটোৱে দিব লাগিব অকল এইটোৱে দিব
Both ways
লাগিব
are represented.
Huh?
Next, according to the applicant, comma, the address of the applicant, comma, as given in the writ petition was incorrect, for which the superintendent of police within bracket border, bracket closed, Morigaon,
মৰিগাঁও
did not accept the bail bond offered by the family members of the applicant. So accordingly, by disclosing the correct address at paragraph 4 of in this interlocutory application, comma, prayer has been made to allow the applicant to amend the address of the applicant in the writ petition. Next paragraph. However, comma, it is noticed that the correct address has not been provided for in the second post title of this interlocutory application. So accordingly, the learned counsel for the, Ms. S.K. Nargis, learned counsel for the applicant, is to allow the applicant to withdraw this interlocutory application to file a fresh. Next, prayer is allowed, the applications, interlocutory application, this interlocutory application shall dismiss on withdraw with liberty as indicated above. This highest tense position.
My lord, may I pray to take up tomorrow? I'm going to file right now, Lordship. Obliged to Lordship.
You have to call for.
Lordship, obliged. Thank
Master.
you.
Upgraded item 35 for admission.
Please, your lordship.
Lord, in this case, my lord, the opinion has been first ex parte. The petitioner before the learned tribunal failed to continue his appearance after submitting his DW1.
Something is wrong. Mr. Pine or Mr. Sharma, whoever is in this matter, Mr. Sharma had been there in the last occasion. According to the last order, We had already heard the item and then it was fixed for delivery of orders.
My lord,
Subsequently, how this went out from the court, we don't know.
my lord, this matter was heard and date was fixed on 4/8/25
What
for
period
delivery
was
of order. But on that day, the matter was not raised, left out, remained left out. Thereafter, the matter was not listed, Your Lordship. Here in this case, my lord, I have very limited prayer, my lord. The matter may kindly be.
How did the matter escape us and
My
get to
lord.
this section? That is the point.
No.
Just wait for some time. Let us make an inquiry what has happened.
কি ফাইল এটা খুলি পেলাই পঢ়কচোন তেতিয়া কিজানি মোৰ তাত ওলাব পাৰে কাৰণ ময়ো নাজানো Upgraded item 36.
In this case, my lord, your lordship kindly peruse the last order, your lordship. Where in this case, notice was not duly served. Expert opinion has been given against the petitioner. There is some direction.
Not probably it was communicated. I may be given some time to get it session.
Act 2, my lord.
Can it be tomorrow or day after? Can it be tomorrow?
Monday.
Monday, Tuesday. Monday, Monday. Can it be on Tuesday?
Yes. Fine. My lord. No, my lord. Some protection may be given, my lord. He did not receive any notice from the tribunal. My lord. In the meantime, some protection may be given, my lord. I shall appear before the SP. Yes. Yes, madam. That. My lord. Notice was placed in the light post.
The part of opinion dated. This is at page 15.
Yes.
Or you can copy also from the last order, huh? That pass by so and so, para 2 of the last order. Next para. The learned counsel for the petitioner has, comma, by referring to the process server's report, comma, has submitted that the process server's report indicates that the notice of the proceedings of the learned foreigners tribunal was pasted in the light post of the village. However, comma, in paragraph 2 of the imperial opinion, ex parte opinion dated 27/6/2024, comma, the learned tribunal has recorded due satisfaction of service of notice. Next paragraph. Under the circumstances, comma, this court, by order dated 5/9/2025, had made the following observations in paragraph 8 to 11 of the order dated 5/9/2025. Full stop. The same is quoted below. Next paragraph. On a perusal of the records of the learned tribunal, comma, the submissions made by the learned counsel for the petitioner is found to be correct, as the process was served in the light post of the village. It was served by pasting it in the light post of the village. And on the night post of the village. Next. Please. Accordingly, the court has no hesitation to hold that the service of notice of the proceedings was not served in accordance with Order 3 of the foreigners within bracket tribunals, the order, 1964. The same is found to have vitiated the ex parte opinion. Next, accordingly, the ex parte opinion dated 27/6/2024, that quote from para 2, so and so is hereby set aside. The matter is remanded back to the learned member, foreigners tribunal number 1, Dhubri. Next para, the petitioner, who is duly represented, the petitioner, namely Chakbar Ali, alias so and so, there's released from the cost title. Also, who's duly represented by his learned counsel, shall appear before the said learned tribunal within the outer date of 13/2/2020
13.
to 26. It's okay? You're getting more than 20 days time. 13/2/2026, and by producing a certified copy of the order, the petitioner shall also file his written statement of defense. No, next panel. The court requests the learned standing counsel for the FT matters to transmit copy of the order dated 5/9/2025, as well as order passed today to the Home and Political within bracket B bracket to department, to bring the order to the notice of the said authority. Next part, the registry shall transmit, return back the records of the tribunal expeditiously. So this refuses transit allowed and disposed of.
Delivery of judgment pertaining to Itanagar bench.
Yes, brother. I have signed it.
Right. Okay.
You may pronounce it, brother.
Okay. We do not find any infirmity in the judgment and sentence imposed by the learned trial court, and accordingly the same is upheld and confirmed, thereby dismissing the instant criminal appeals. The victim compensation has been enhanced to ₹10 lakhs.
Much obliged, Lordship.
Time being item 35.
Mr. Rahman is not there. After some time.
Upgraded item fixed at 2 p.m. Item 32.
State respondents have filed the affidavit matter. In this case, matter. Matter may be taken up for disposal on 29th, matter.
Only one ground, your lordship, this detention will go, your lordship. That's, your lordship has already settled that position of law, your lordship. Not informing the detainee about his right to submit representation before the detainee court. Very recent judgment from this honorable court, your lordship, on that point. And that's an admitted fact, your lordship.
Just a moment.
Lords,
Just a moment.
lords. এবার নোটিশ ইস্যু করেছে।
Then I don't have petition. That's it. Yes.
Yes, that is a matter. My prayer is to take it up on 29th for disposal, my lord. No, yes. Yes, right, my lord. My lord. All right, if he can start it, my lord, I can, my reply on 29th. Thursday, 29th is Thursday, my lord. Yes, there you go. But today I'm not in a position to, my lord, make my submission.
The petitioner, your lordship, the detainee, your lordship, was initially arrested in connection with a case, your lordship, and that's Potasi Lambari PS case number 137/2025. He was arrested on 26/9/2025, your lordship. Now, on the same day, he was produced before the learned trial court, your lordship. And the learned trial court, your lordship, granted him bail, your lordship. He was arrested on 26/9 and produced on the same date, your lordship.
Potasi Lambadi case.
Potasi Lambari. We have annexed the order granting bail at page 41. your lordship.
Where is the list of date?
List of date, your lordship, I have not. But along with the petition, your lordship, that is there, but separately I have not.
What happened?
On 26/9/2025, your lordship, 26/9/2025, he was arrested in connection with Potasi Lambari PS case number 137/2025. On that day, he was produced.
In connection with Potasi Lambadi PS case.
Yes, your
Or
lordship.
Azira PS case.
No, it's Potasi Lambari PS case. That's Potasi Lambari PS case number 137/2025.
He was arrested for
He
that
was
case also.
arrested, then produced, and on the date of production, he was granted bail, along with others, your lordship.
No, what happened to the Azara case? Then
Then your lordship, when he was
taken out, then he
released
was arrested.
from the court premises itself, he was again arrested in connection with Azara PS case number, that is,
142.
yes. Then while he was under custody, your lordship, in Azara PS case number, Azara PS case, on 7/10/2025,
We have a look at both the FIR.
lordship, that is, that your lordship will get that page. Azara to police. Your lordship will kindly come to page 76. This is Azara, your lordship.
Well, you were first arrested with Bharati number.
Lordship, but your lordship, Azara was the first.
Therefore, first in point of time.
First in point of time. May I read your lordship? Second, lordship.
It's a following list of the present sections of the VNL. Can we just point out the what is the section 191 to 190 to 96? Just set up the
Lordship.
section.
192.
And it goes back to the IPC.
Lordship, lordship. Lordship, this BNS sections we also.
Page 72.
191 is rioting, your lordship.
Page 72.
Lordship.
191 is writing.
Right.
Right.
190. It is unlawful assembly, Your Lordship. Lords.
296.
296 is obscene act and songs.
Please come again.
Obscene act and songs.
Okay.
Act and songs.
Act and songs. 324 is mischief.
109 attempt to murder.
Attempt to murder. 132. Assault or use of criminal force to deter. That's earlier 353 euros.
And then what is 52, 54 and 57?
Abatement, Your Lordship. Abator.
Abatement.
Your Lordship.
61.
61 to Your Lordship, that's conspiracy.
Okay. And what is the next paragraph?
That's Your Lordship, the Patasi number.
Yeah.
Your Lordship will get it at page 84. That's actually. The earlier case, I was not named. Here I am named, along with others.
One 189 section.
Lordship, 189 is unlawful assembly rules. 189, 191 2 is Your Lordship.
126.
126 is wrongful restraint, Your Lordship. And 125 is act endangering life or personal safety of others.
Yes, okay.
Now, your lordship, while he was under custody in connection with the Hazara PS case, the order under section 3(2) of the National Security Act, your lordship, was passed and served, your lordship. That your lordship will get it at page 47 of the writ petition. Lordship, he was in under custody. May I read this order, your lordship? Page 47. Lordship. Then, your lordship, this order was passed, and on 8/10/2025, grounds of arrest were furnished to him.
Because this is almost a mixture of the entire.
Lordship.
It gives an idea of what is.
Lordship.
And therefore, this preventive is required.
Lordship. Lordship.
In that.
Now, your lordship will, on 8/10/2025, grounds of arrest were furnished to the petitioner. And on 14/10/2025, the state government, your lordship, approved the order of detention on 14/10/2025. Page, your lordship will get it at page 169. The Governor of Assam, as per provision of subsection 4 of section 3 of the National Security Act 1980, after considering all the facts, is pleased to approve on 14/10/2025 the detention order passed by the Commissioner of Police, Guwahati, memo number so and so, under subsection 2 of section 3 of National Security Act 1980, detaining 3 so and so, a resident of. Now, in none of the orders, in the initial or detention order by the detaining authority, the district magistrate, as well as the governor's order, the time period has not been mentioned, your lordship, for how many days he was.
That was which page I missed out? Which page was
169, your lordship.
Yes.
Then, your lordship, on 22/10/2025, I file a representation, your lordship. That is at page 179. Page 170. That's my representation to the government of Assam, the government of India, and the chairman of advisory boards. Since I was in the meanwhile informed about my right to represent before the central government, that's why 3 authorities I have sent my representation. That is at page 170. Then, your lordship, on when that your lordship will get from the affidavit filed by the state government on 20.
You did not give it to the detaining authority.
Lordship?
You did not give it to the detaining authority.
No, because I was not informed, your lordship.
Come back to that letter.
Lordship. 22/10/2025, the superintendent of the central jail, your lordship, he forwarded it to the government, your lordship.
Please come back to that, detention where you said that.
Lordship. That page 47, your lordship. Page 50, your lordship will find. If the detainee desires to make a representation against the order, this order, he may do so to the Additional Chief Secretary, Home and Political Department, Government of Assam, or directly to the advisory board. Page 50, last paragraph. And your lordship will find it again in grounds of arrest at page 54, right to representation. You have a right to make representation to the government of Assam and to the advisory board under section so of National Security Act. Such representation may be submitted to the superintendent of Central Jail, Guwahati. You may also request personal hearing before the advocate.
The home is not upgraded itself.
Lordship.
Home is not upgraded itself. What is it then when you pass the last order?
Yes, sir, that it is, it is given, sir.
It's okay, and you will understand.
Lordship.
Lordship. Now, Your Lordship, the Superintendent of Central Jail, Your Lordship, forwarded the representation on 23rd, Your Lordship, that Your Lordship will get it at page 225. That is the affidavit filed by the state government. Annexure G, page 225. Lords. Then on 30/10/2025, para was comment was sent by the retaining authority to the government, Your Lords. That Your Lordship will get it at page 219. Lords. Now it was the parawise comment was furnished by the retaining authority of the state government on 31/10/2025, Your Lordship. And if Your Lordship goes through that covering letter at page 219, Your Lordship will find that first it was first put up on 4/11/2025. And that delay has not been explained. And finally, Your Lordship, the Lordship.
Yes.
Now, Your Lordship, finally, Your Lordship, they passed the order rejecting my representation on 7/11/2025, that is at page 239. This was dated 7/11, 2025. Now, this order, Your Lordship, although was marked to me, Your Lordship, but however, as per my instruction, Your Lordship, this was in fact not served upon him. That's my instruction, Your Lordship. Even though, Your Lordship, even assuming it is served, Your Lordship, even then, Your Lordship, this detention is bad, Your Lordship. Now, these are the facts, Your Lordship. Now, if Your Lordship comes to the order of detention at page 47, Your Lordship. Lordship. First, Your Lordship, not informing the detainee about his right to submit representation before the detaining authority, Your Lordship. That is one, Your Lordship. Secondly, Lordship. Second is, Your Lordship, non-consideration of the fact that he was already under custody by the detaining authority, Your Lordship. Not in Ajara, Your Lordship. Fatasi Lambari, he was in Ajara PS case. One 42 of 2000. 142 of 2025. And third, Your Lordship, non-furnishing of relevant materials, Your Lordship, on which they have relied on. And delay in disposal of the representation, Your Lordship. And finally, your lordship, non-application of my by the detaining authority. That is apparent, your lordship, in the affidavit filed by the Commissioner of Police, your lordship, detaining authority. He has submitted, he has stated that they have referred to 10 FIRs, your lordship. The detaining authority in the sworn affidavit has said that it is due to oversight they have included those cases in the grounds of arrest as well as. Can that happen, your lordship, in a case of National Security Act? That clearly shows non-application of mine by the detaining authority. Lordship. Lordship. Lordship. Now, your lordship may kindly come to page 47. 47. That is the order of detention, your lordship. Lordship. Lordship, it will be better if your lordship, the entire matter is heard at one go, your lordship. Lordship. Lordship.
This currently already have.
Lordship. That is the. Your lordship, I can do one thing, your lordship, to your lordship, subject to what your lordship said, your lordship. I can prepare a short, your lordship, synopsis of my arguments, your lordship. Last occasion also, I have handed over that, your lordship. That will probably shorten the time of argument, your lordship, and then. Basically, your lordship, only on one count, your lordship, this will go, your lordship, because in the, both the affidavits, right now, lordship. That ground, your lordship, I will argue right as today, your lordship. Lordship, I know, your lordship. Only on that ground, lordship. That your lordship, already, your lordship has already seen, your lordship, from the order of detention, neither in the order of detention nor in the grounds of arrest, your lordship. They have spoken about my right to represent before the detaining authority. That is apparent. And in fact, your lordship, if your lordship takes up the reply affidavit in opposition filed by the Commissioner of Police, your lordship.
You see, not on every day you will find cases of NSA being taken up, National Security Act. You can follow this argument which is going on, and you try to make your legal study on this National Security Act. Please follow what is being argued and make your what do you call this write up on this point. That's right. You can take your seat.
Now in that affidavit, your lordship will kindly come to page 258, para 19. May I read your lordship that paragraph? Page 258, para 19. That as regard the statements made in paragraph 19 of the writ petition, the deponent beg to state that the respondent number 4, that is the Commissioner of Police Guwahati Assam, has issued the detention order in pursuance of the notification by number PLS so and so dated 21/8/2025. While issuing the order dated 7/10/2025, the respondent number 4 also stated that the petitioner, if so desires, make a representation against this order to the Additional Chief Secretary of Home and Political Department, Government of Assam, and directly to the advisory board. This has not been denied, your lordship, and in fact, in para 19 of my writ petition, I have made a categorical statement. Select. In para 19, I have made a specific reading that the petitioner most importantly begs to submit that he was also not informed about his right to file a representation before the detaining authority, that is the Commissioner of Police Guwahati. The detaining authority in exercise of power under section 14 of the National Security Act, agreed with section 20 of the General Clause Act 1897, has the power to revoke the detention order. Thereby it is incumbent upon the detaining authority to inform the petitioner about such right of his and thus enable him to file such representation. Such omission in the present case clearly amount to violation of the petitioner's fundamental right under Article 21 and 22(5) of the Constitution of India. That has not been denied. An evasive answer has been given by the detaining authority, saying that I was informed about my right to represent against the order before the government of Assam, India Advisory Board. Now your lordship's judgment has settled this position, your lordship. Page 200, last judgment annexed to the this. Para 34, your lords. Page 219. WCC Criminal 42/2025. Page, your lordship, para 34, page 219. Nice. May I read your lordship? What follows from the above is that the detaining authority, while issuing an order of preventive detention of a citizen, did not follow the rigors attached as condition for exercise of the powers. The detaining authority did not inform the detainee of his right to prefer a representation to the detaining authority itself. The question whether the detainee under the National Security Act 1980 or short act has a right to make a representation to the detaining authority in addition to his right to file representation as provided for under section 8(1) of the Act to the appropriate government, and whether Article 22(5) of the Constitution of India confers any such additional right, receive attention of this court in more than one case. In the case of Kansam Brajen Singh versus State of Manipur and others, decided by a full bench of this court and reported in 2006 1 GL 375, the judgment of the Apex Court was considered, and this court held as follows. Then it is considered opinion of this court, the lapse on the part of the detaining authority is alone sufficient to vitiate the detention imposed on the petitioner, your lordship. And on that basis, your lordship, at para 39, your lordship's final verdict. In the present case, there is no explanations for the time consumed by any authorities while dealing with the representation filed by the petitioner. Coupled with this, the petitioner was never informed about his right to represent to the detaining authority. And further, his right to represent to the central government came to be informed to him only after central government has reminded the additional Secretary of Assam with a copy to the district magistrate Naga. In view of what has been concluded above, the court does not consider it necessary to go into the other points raised, as the court is satisfied that is said one reason alone, the detention order stands vitiated, and other issues raised by the petitioner are not required to be examined. Yeah. Now, issue has been settled, lordship, and central government has, that information has been given to us. No, here it was given. Here it was given. In that particular case.
In your case you had. So it was,
Subsequently, I was informed about my right. That's why I have represented before the central government, and central government rejected my representation. Now, Kansam Brajen Singh says, my argument is, your lordships, I was not informed about my right to represent before the detaining authority. And Kansam Brajen Singh has said that if failed to inform the detainee about his right to represent before the detaining authority, that detention will not be legal, your lordship. That's what referred to by this honorable court in this judgment also, your lordship. Your lordship may kindly come to page 220, your lordship. The judgment of the full bench has been quoted here. Lordship. If your lordship comes to page 220, your lordship. Lords. Lords. Page 220, your lordship. There, page 220 of this judgment, your lordship. This one, yes, sir. That your lordship reference to the full bench judgment of this honorable court, where this honorable court has very clearly held that detaining authority is under constitutional obligation to inform the detainee of his right to make such a representation to the detaining authority. And 4, the failure to inform the detainee of such right to make representation to the detainee authority vitiates the detention order made even under the provision of National Security Act. That cleanses the issue, your lordship. And apparently, your lordship, I need not go further, your lordship, on that count alone, your lordship, this order is required to be set aside in post.
Uh, 20
22nd থেকে tomorrow my lord.
Financial for it, 27. 29.
Petitioner remains inconclusive. First of all, he has handed over a compilation of judgments, which is made a part of record.
Or basically very good.
Full stop.
এটা point out হতো।
Mr.
Total যদি কিছু ইয়া।
B. Goswami, Learned Additional Advocate General for the state, assisted by Mr. D. Nath, Learned Senior Government Advocate, and Mr. P. Sharma, Learned Additional Senior Government Advocate. Please that the matter be taken up on 29/1/2026. Mr. K. Parashar, Learned CGC is present. For respondent number 1. Next para. List the matter on 29/1/2026 as a part and matter. Yours.
Always.
Item 35.
Okay, Mr. Ahmed, we'll have to take up the matter for hearing because the last hearing left, we are in a different bench now. On merit, what do you have to say?
My lord, here in this case, your lordship, expert opinion has been given. He said the petitioner appeared and the file is WS then DW1. Thereafter, he failed to continue his appearance before the tribunal. And accordingly, this expert opinion has been given. And there is some wrong assessment matter regarding the voter list. My lord, my limited prayer is that, my lord, for better adjudication in this case, your lordship, the matter may kindly be remanded for test.
So you'll have to satisfy us that what are the reasons for not being able to be present?
My lord. But the petitioner before I talked it, he said,
You remain absent without steps. So therefore, what is the explanation now? In the petition, what is the explanation tendered?
I have stated, my lord.
Which paragraph?
Para number 15, your lordship. He is in detention camp for about 8 months, Your Lordship. I think he got sufficient punishment, Your Lordship.
Where is the photos list of 66?
66 voter list, Your Lordship.
This
Yes.
contains the name of your father.
My lord, Zolishka.
This is exhibit 1.
My lord. Case 31, the voter list, 66. The name of the present petitioner is also reflecting along with his father
Where?
in the voter list of 2005, Your Lordship. Page 38. Here,
Just a moment. After this, which is the exhibit 3? What is exhibit 3?
1970 voter list. Page 33.
What is exhibit 6?
It's under the. List of 2011. Under the 2005 total list. At place 38 year also. But the name of the petitioner is reflected in total list along with his father.
And what is your explanation for the delay?
My lord.
What is your explanation for the delay in what was the?
I thought he actually went to the state of Meghalaya, Shillong for doing labor. Immediately after coming
No,
from.
which paragraph you have stated that? Explanation of the non-appearance?
Para number 15, your lordship.
15.
There was my lord, he has good case, your lordship. Only one opportunity.
Mr. Sharma?
Lordship. Lordship, it is not the case that he is never aware about the proceedings, Lordship.
He's aware of the
He-
proceedings, but
And he contested the case, Lordship. After that,
having
you know,
noticed that he's in the custody for 8 months, he will send him back for a contest. Let him contest the matter. He's been inside for eight months.
yes, Lordship, but Lordship, my humble submission is that there is no infirmity in the opinion.
No, it's this,
Yes.
but
So Lordship, if Lordship is willing to send back the matter, then Lordship, some cost may be imposed, Lordship.
he says he's a labor.
Otherwise,
What cost will impose? He says that he's a labor.
He is having 4 minor children. 3 minor children, my lord. He is in detention camps. His wife is suffering a lot, your lordship, with 4 minor children.
No, he's asking for cost because of your reputation.
And
Because of your reputation, he's asking for cost. The labor would not come to you. But you see, we have some difficulties in accepting very bland statements. You make allegations against the lawyer. You don't disclose their names. You don't take action against the lawyers.
No, my lord, I have not taken the allegation yet.
Well, if the allegations are not correct, then why would we set aside the tribunal's orders?
So for better adjudication, my lord.
No, it's not a question of better adjudication. You are making an allegation that your advocate did not contact with you. He did not inform you. You don't disclose the numbers through which you wanted to contact him. Everything is very, very vague.
Has no mobile phone yet.
But mobile phone, we don't find that one can be out of contact for eternity. I will be out of contact for some time because of the network problem. But that is, right, it can't be accepted.
At any condition, my lord.
No, you see, when you make statements, you see, I'll tell you what we see. You have seen laborers working on road PWD roads when they work, when they construct houses, when they do the dhalai job. You have seen labor working. What do they do? In every construction, whether it be a carpenter, whether it be a mason, whether it be anyone, they would first put on the songs in mobile phone.
But
First thing is songs. After songs, they start working.
but I have found him very peculiar. He has no mobile phone. My lord,
Then how did you contact?
honestly submitting that.
Then you please tell us, you see, you are in Shillong. How did you contact if you don't have a mobile phone? These are things which makes the story very unbelievable. Even if we want to, we can't, because you make statements where you can't come out of it. How do you make a contact? Since you are a laborer in Shillong, you would not be having a landline connection.
His other family members inform the English.
But that is not the case projected. You say I contacted. You don't say your family members contacted. And who's that family member who want? The story must be perfect. We are setting aside an ex parte opinion. We must have a good ground.
Technically, my lord, it is the fault of the petitioner, you know.
Pardon me?
My lord, it's the fault of the petitioner in appearance here also. Otherwise, he has to face a lot of every document here also. His father is alive here also. Whose name is found to be recorded in the 1966 photo. In the 1951 NRC also. His father's name is there.
Because Mr. Hamid, you are, in fact, your statement in this paragraph 15, we are trying to read again and again. You are in fact protecting your lawyer. You are saying, instead of you trying to contact the advocate, you say that my lawyer wanted to contact me on several occasions, but failed because I had no mobile phone. Therefore, the lawyer is not at fault. You did not contact. So under that circumstance, how can you make out a case that we should set aside an ex parte opinion, even if we want to?
In the informed opinion, your lordship. Wrong assessment has been given, your lordship.
Only
The voter list of 2011, your lordship. In the voter list.
please repeat again. We are not getting you. Is your speaker on? Yes.
My lord, in respect of the voter list 2011, your lordship.
Yes.
There is some wrong assessment in the informed opinion, your lordship. Your lordship will find at page 55, your lordship.
50? 50?
Page 55, your lordship.
55 we have seen.
My lord.
You have mentioned that in the electoral law of 2011, there is one Hashim Ali Khan and Hassan Ali Khan along with others. And Procedural has not disclosed his siblings and intricate details of his family. You want us to read this?
My lord.
Come to your 2011 voter list.
There's
That is-
names, two different persons, my lord.
That
Hashim
is
Ali
that-
Khan and Hassan Ali Khan, my lord.
Yes.
Both are two brothers, your lordship. Step brother of the petitioner. Here, one Azima Khatun is shown as wife of Hassan Ali Khan. This Hassan Ali Khan is the step brother of the petitioner. Claimed by the proceedor to be himself in place of Tarabhanu. My lord, Tarabhanu is the wife of the present petitioner, your lordship. Your lordship will find in the voter list
No,
of
no,
2005.
Come to page 40 of the petition.
Page 40.
Yes.
41.
This is electoral law of 2011.
11. Here, my lord, Hassan
there
Ali
is-
Khan.
No, there is no, what is this attached here?
My lord?
This is on the first page. The voter list is not here. After page 40, 41 is not there with us.
41, yes, yes.
It's not there.
No.
It's not there.
My lord,
No, we'll read from our brief. We will not read it from your brief. Page 41 is not there either in first copy of the petition, second copy of the petition, neither with the government advocate.
my lord, your lordship, may kindly peruse the record, your lordship, the voter list of 2005, your lordship.
Records, did you call the record?
I am sorry for this, your lordship. LCR is received, your lordship.
Just see the LCR.
Exhibit 7, Your Lordship.
Yeah.
Your Lordship, Jolish Khan is his father. Hajra Bibi stepmother, Rohim Khan brother, Anwara Khatun son-in-law, sister-in-law, sorry. Hassan Ali Khan, this is the petitioner, Your Lordship. Hassan Ali Khan, father's name is recorded Jolish Khan. This Tara Bhanu is the wife of Hassan Ali Khan. This is the petitioner. Here, Sofiul Khan, this is brother, my lord. Next, Hassan Ali Khan. Difference is Hashem and Hassan. This Hassan Ali Khan is the step brother. My lord, initially this person received the notice, my lord. After his appearance, he verified the record and found that he is not this person. His brother is
The
the.
tribunal says that there are two names in the voter list. You don't give the details of your family members in your written statement. How would the court take notice of that?
My lord, that was stated in the written statement, my lord. At page 21, Your Lordship. One step brother, namely Hassan Ali Khan, who received the notice and subsequently discharged. My lord.
Paragraph?
At page 21, para number 12, B, below. Down below, para number 12. One step brother, namely Hassan Ali Khan, who received the notice and subsequently discharged as aforesaid, and two sisters. In the evidence of DW1 also stated.
What do you mean this by you are writing? One step brother, namely Hassan Ali Khan, who received the notice and subsequently discharged as aforesaid. What is the discharge as aforesaid?
My lord, initially the step brother of the petitioner received the notice. Name is something identical, so he received the notice. He appeared the tribunal and verified the record. Upon verification, he found that he is not the person. His elder brother is the proceeding. Thereafter, one petition was submitted, and accordingly, that was allowed and discharged his appearance. And this petitioner willingly appeared and tried to contest the case, Your Lordship. It is not that he received the notice, my lord. The present petitioner was informed by his younger brother that one case is pending against you. You come to the court and to contest the case. Accordingly, he appeared, my lord. So, my lord, his non-appearance before the tribunal is not intentional, Your Lordship. And for that, my lord, he got sufficient punishment, Your Lordship. For about 8 months, he is in detention camp, your lordship.
Okay. Mr. Sharma,
Lordship,
just go through the orders of the tribunal.
Lordship.
You'll have to rise in the meantime, if that statement is correct. Then accept it.
Lordship.
The orders at 26/7/22. Just go for the, please be satisfied. If anything is wrong, tell the court master. If everything is right, then also tell the court master. We'll come to know about it. Okay. Subject to what you say, we'll pass orders in the chambers. Other matters we may not have time to take up.